If this is your first time on my channel, my name is David Gotch. I'm an Illinois attorney. Way back when I went to law school, my dream was to become a public defender, just like Reed Hadley on the TV series, and that was to the chagrin of my father. He was a career state trooper, and my grandfather, who was a career MP in the U.S. Army. However, fate's kind of a funny thing, and I end up finding myself as a private practitioner, which I've done for the last 11 years. But last year I did fulfill my dream in a way. I was among several lawyers selected to be in the Illinois Supreme Court's Appellate Pilot Program, which works with the Office of the State Appellate Defender, representing indigent persons on appeal. And for me, that was an incredible honor, and it's a privilege, and one that I take exceptionally seriously. And I just mention this because as I read this bill, I'm really torn about it. Some parts seem like really great ideas, but others, honestly, I'm not too sure about. I recently attended a CLE on the new crime bill last week. For non-lawyers, that's called a continuing legal education. In Illinois, lawyers have to attend approximately 24 hours worth of training on an annual basis. At the CLE, I think we had about 55 or so lawyers. If you had read the prospectus for the CLE, it certainly implied that it was going to cover the new crime bill. And to be fair, there were a couple speakers that did touch on it, but overall, I felt it was a missed opportunity that spent more time discussing tangents than actual black letter law. So I did what any lawyer would typically do. I pulled up the entire 800-page bill and I just kind of read through it myself. And here, I'm going to share my thoughts on what certain segments of the bill means and what I think they don't mean, and where honestly I have no clue. Now, to be clear, I'm not going to opine on whether this is a great bill or a terrible bill. Unlike the 1970s or 80s or even the 90s, that's kind of the era I grew up in, today's generation really no longer discusses policy. Like, does it make sense to punish someone more severely for having crack cocaine versus powdered, despite the fact that they are typically chemically identical? Instead, it seems it's all been reduced to politics. And what I mean by that is, oversimplified talking points or ad hoc slogans, such as, if you were against the crime bill, you were a racist, and if you were for it, you hate cops. Sadly, it seems the loudest voices on both sides of the debate haven't read the bill. And worse, the decision makers upstairs passing these kinds of laws probably have never stepped foot in Austin or Inglewood. In my mind, crafting policy without actually seeing what's happening on the ground floor, well, it's a recipe for disaster. But be that as it may, this is the law. Obviously, this is a one-way conversation. It's not legal advice. I'm just sharing my thoughts as a lawyer and nothing more. As you know, use of force has undergone a substantial overhaul. Use of deadly or very serious force to effectuate an arrest is now a 3-part test, and you must score a yes on all 3 before said force can be deployed. So part 1, the officer must reasonably believe, and reasonableness in legalese means that the average person would have come to the same conclusion, that deadly force or serious force is the only way to perfect the arrest, and the person resisting cannot be apprehended at a later date. Second, it must be clear that without the arrest, the person is likely to cause great bodily harm to another. And 3, the person must have just committed or attempted a forcible felony which involves the infliction or threatened infliction of great bodily harm, or is attempting to escape by use of a deadly weapon, or otherwise indicates that he will endanger human life or inflict great bodily harm unless arrested without delay. Now notice in regards to that last prong, the word just has replaced the previously used term has. The old law implies, any time, whereas the new law seems to require a very short period of time, perhaps mere minutes. Otherwise, deadly or serious force is off the table. On top of that, the statute now requires the officer to evaluate the, quote, totality of circumstances, end quote, as part of their calculus. Totality of circumstances in this case means all facts known to the peace officer at the time, or that would be known to a reasonable officer in the same situation, including the conduct of the officer and the suspect leading up to the use of deadly force. So it seems there's a lot of tripwires here, and from my standpoint, if there's any uncertainty as to whether all 3 factors plus the totality of circumstances test have been met, prudent thing may be to let the offender go and have somebody else worry about it if the arrest cannot be perfected. A few other things of note. A-5 requires police make an effort to identify themselves and to warn they may use deadly force. However, this isn't required if there's no time to explain or if it's pretty clear the suspect is aware you're a cop and about to use deadly force. A-10, deadly force isn't allowed against suicidal persons unless a reasonable person, and recall that reasonableness standard from before, believes the person poses a threat to somebody else. A-15, deadly force isn't allowed for property offenses unless it's terrorism. The statute itself has a lot of paragraphs that are really, proclamations that deadly force is a serious thing. I did feel one of them was worthy of mention, subparagraph F. The decision by a peace officer to use force shall be evaluated from the perspective of a reasonable officer in the same situation, based on the totality of circumstances known or perceived by the officer at the time of the decision, rather than with the benefit of hindsight, and that the totality of the circumstances shall account for the occasions when officers may be forced to make quick judgments about using force, end quote. So a simplified way of saying this is if it turns out the weapon was a BB gun, the officer theoretically shouldn't be stripped if he used deadly force. However, the running theme is that deadly force when used must meet a new, higher threshold under the new statute. Now I'm going to cover use of prohibited force. For example, we have a new chokehold policy. Subparagraph A through B, no chokeholds or restraints above the shoulders at risk asphyxiation unless applying justifiable deadly force. Keyword to remember here is risk. Chokeholds are now defined more narrowly. The intent requirement is really no longer part of the calculus. Incidental or accidental contact may now count. Subparagraph D, the term restraint above the shoulders also includes the head, but note it applies after the person is no longer deemed a threat. Subparagraph E, subparagraph 2, use of non-lethal projectiles like beanbags or rubber bullets is not allowed if you target the head, pelvis, or back. Now, if you ever fired one of these, unless it's point blank range or you're Annie Oakley with the beanbag gun, I'm not sure I'd ever want to advise a client to discharge one of those weapons given those tripwires. You could be aiming for an allowed area, but let's say the subject moves at the last second. And if you're CPD, in that situation, you may have to hope that COPA believes you. Subparagraph 4, tear gas or pepper spray isn't allowed unless sufficient warnings have been given first and there's been time to comply. Now, how much warning or time to comply isn't really indicated in the statute. I imagine that this is really a decision that higher-ups are going to make, so it's not something that's going to impact regular police officers. Now, this is after the person has obviously been arrested and they're trying to get away. Essentially, use of force is allowed, but not deadly force or serious force unless it's necessary to prevent death or great bodily harm to the officer or another person. Interestingly enough, this applies to prisons as well. So, in an exaggerated sense, if you have a group of mass murderers do a jailbreak at once, it seems from a liability standpoint, I would want to remind the guards that unless normal force isn't going to be successful, don't use deadly force, just let somebody else handle it. This essentially requires that once deadly or really any force is used, you must provide medical assistance to the person that you've applied that force to as soon as reasonably possible. This provision requires police to report on other cops if they feel their partner or whoever is using more force than what is legally required under this new law. The running theme you'll see from this segment of the law is that, if the situation doesn't meet this new threshold and normal force is not going to get the job done, the safer practice might be to let the offender go and let somebody else handle it. One other thing regarding regular force, the chokehold or restraint above the neck doesn't have to cut off airflow. The new law only requires that there be a risk of that. And as previously discussed, intent is no longer a requirement, so accidental or incidental contact may trigger this prohibition as well. I feel officers may wish to keep this in mind before putting hands on a suspect for really any reason, as struggles aren't well choreographed things, unlike what you see on the movies or TV. Now, to be clear, I'm not suggesting police shouldn't use force. I'm just saying, this is what the statute says. If there's doubts about what the statute says, what do we expect a police officer not wanting to be hauled before COPA going to do? Is he going to keep going and risk an inquiry that could end his career, or is he just going to let them go and let somebody else deal with it? And another question here, if an officer is following this policy to the letter, wouldn't it be reasonable to assume that all an offender has to do to avoid detention is to, kind of on their own, escalate the situation enough where those factors allowing deadly or serious force aren't triggered, but where traditional means will no longer suffice for the police officer. And that's not a question of politics, that's a question of policy. Questions I fear officers may be asking themselves as they look at this new law. And if they do disengage, how is the public going to react when they see that? As you look at the numbers, carjackings are at a historic high in Chicago. According to the statistics site Hey Jackass, shootings are up as well. And despite the provocative title of their website, no one's been able to dispute that their numbers aren't what they are. Things are bad, and the question is, are they going to get worse? So a question I wish that was discussed is, what does this policy do to those numbers? Are they going to decrease them, or will they embolden criminals and push those numbers even higher? This is something I wish both sides had taken the time to discuss before ramming this bill through. Regardless though, this is the law now, and here we are. Anyways, that's all I have for use of force. If you like these summaries, feel free to subscribe. I'm going to have future installments here, probably on a weekly basis, covering other segments of this nearly 800-page crime bill.